Bismillahirrahmanirrahim. Assalamu alaikum, everyone. Welcome back to the official YouTube channel of the Islamabad Policy Research Institute. My name is Ikra Banu Suhail, and I am a research associate with the Chair International Law here at IPRI. आज की हमारी podcast will focus on the recent advisory opinion given by the International Court of Justice on obligations of state in respect to climate change. इसकी क्या significance है, क्या नई obligations इसमें identify की गई हैं, and the importance that it holds for Pakistan. ये सारी चीजें हम आज discuss करेंगे. And to talk on that, we have Shayan Ahmed Khan joining us today, who is a dual qualified lawyer in New York and Pakistan, currently working as an associate in the international arbitration practice of Wilkie Farr and Gallagher. Shayan has previously worked at the Permanent Court of Arbitration, the International Committee of the Red Cross's Permanent Observer Mission to the United Nations in New York, as well as the International Disputes Unit of the Office of the Attorney General for Pakistan. Notably, he was Pakistan's co-counsel in the ICJ advisory opinion on the obligations of states in respect of climate change, which is the topic of our discussion today. Thank you so much, Shayan, for joining us today on such a short notice. We're really thankful.
Thank you, Vikra. Pleasure to be here.
Yes. So, Shayan, let's just get straight to the point and talk about this very elaborate opinion given by the court. So, what are the key legal obligations that the ICJ has identified for states regarding climate change in its opinion?
So there's a great deal to unpack in your question and in the court's advisory opinion, and I hope down the line we'll have the opportunity to do a more detailed deep dive. But given that the purpose today is to broadly explain the court's holding, I'll avoid getting into the specifics of some of the issues which honestly each and every one of them raise very important and complex questions under international law. But before I turn to your question specifically, I'll just briefly mention where those obligations stem from, because this was one of the most contentious issues during the proceedings. So during the proceedings, both the oral rounds and the written phase, developed states, rather some of the developed states, were arguing that the UN Framework Convention on Climate Change and the Paris Agreement constitute a lex specialis regime, and that legal obligations relating to climate change can arise only under these treaties. So the court, in its advisory opinion, rejected that view. Instead, it held that states' obligations stem not only from the UNFCCC and the Paris Agreement, but also from a broader body of international law. So this would, of course, include under treaties, the UN Convention on the Law of the Sea, the Convention on Biological Diversity, the UN Convention to Combat Desertification, as well as a number of other human rights treaties, and of course, the UN Charter as well. More fundamentally, though, a lot of the obligations and a lot of the opposition came about from the obligations that exist under customary international law, because those obligations date far back in time. And if the obligation to prevent harm to the climate system can be dated back to a particular point in time, sort of, let's say in the 1900s, then the discussion would change completely, because the UNFCCC and the Paris Agreement are relatively newer, the UNFCCC being here since around the 1990s. So, given this expanding reading of the applicable legal framework, the scope of obligations was necessarily broad, and the court examined several obligations. I'll try to give a more holistic view of some of the major ones.
Okay.
So, the first one was, of course, the mitigation, adaptation, and cooperation measures under the UNFCCC and the Paris Agreement. And there, the court entered into a treaty interpretation exercise and gave significantly more legal force to these measures under these treaties. For example, in relation to mitigation, the court examined obligations relating to the preparation and update of national greenhouse gas inventories and formulating and publishing national climate programs. Now, importantly, the court read in that many of the provisions under these treaties are an obligation of result as opposed to conduct. So what does that mean in practice? It means that they're not merely procedural duties, but instead, if a state fails to achieve the required outcomes, such as the emission reduction targets, it may incur international legal responsibility. Okay. So put another way, the court has said it is not enough to adopt policies in form only. They must be capable of delivering the required results. And then importantly, on nationally determined contributions, the court emphasized that the phrase highest possible ambition under Article 4 of the Paris Agreement does not grant unlimited discretion to states. Rather, states are required to act with stringent due diligence and to make every effort to achieve the 1.5 degrees Celsius target that is set out under the Paris Agreement.
Hmm.
So, in other words, the highest possible ambition under Article 4 of the Paris Agreement is not considered aspirational. It is legally constrained and must be substantiated by credible science based action. I'll take a bit more time to now go into customary international law, knowing I've already sort of taken a fair bit of time to answer this question,
No, no, it's
but
fine.
bear with me. So, customary international law, as I mentioned, was an important part of the equation. So, there, the International Court of Justice noted that due diligence is the required standard of conduct for the duty to prevent significant harm to the environment. Now, what does this mean? It means that states must design and implement appropriate rules, including regulatory frameworks aimed at achieving deep, rapid, and sustained reductions in greenhouse gas emissions. And crucially, this obligation extends beyond the conduct of states themselves. Now, this is a very important point, which I think we'll discuss later about the repercussions of the advisory opinion. But the court said that states are not only required to regulate their own conduct, but also the behavior of public and private actors within their jurisdiction and ensure that these regulations are enforced and monitored effectively. And the duty to prevent significant harm also entails several specific other responsibilities. So, for example, taking measures considering the best available scientific and technological information, conducting risk assessments and environmental impact assessments, notifying and consulting with other states when there is a risk of transboundary environmental harm, and in addition to that, the other duty under customary international law pertains to the duty of cooperation. So, of course, we know that climate change as a is a challenge that is common to the international community as a whole, and in that regard, the court said that states must make good efforts to reach appropriate forms of collective action, such as technology transfer, capacity building, and financial support, especially to meet the 1.5 degrees Celsius target that is set under the Paris Agreement. And then, of course, it would not be uh, prudent of me to end here. And I will also add that the court also shed light on the applicability of international human rights law to the to issues relating to climate change. So it mentioned, for example, the right to life, the right to
Yeah.
health, the right to an adequate standard of living, the right to privacy, family, and home, as well as the rights of women, children, and indigenous people. And the
Hmm.
court said, of course, these rights are non exhaustive. So the court generally spoke about the applicability of human rights as a whole. And it also recognized the right to a clean, healthy, and sustainable environment, which, in the court's opinion, is an essential precondition for the enjoyment of all other human rights. And having spoken for a very long time, I'll pass it back to you. I hope this was somewhat helpful.
Okay, wow. So indeed, a very broad scope from what you've told us. So, Shayan, throughout this thing, we saw the idea of developed versus developing world being reflected, right? So, how does the advisory opinion address the responsibilities of developed countries compared to developing and vulnerable states?
Right. So the court placed a significant emphasis on this structural imbalance between states, as you rightly mentioned, particularly in terms of historical responsibility and present day capacity to address climate change and the challenges there too. So it gave considerable weight to what we know as the principle of common but differentiated responsibilities and respective capabilities. We'll
Yes.
just call it
Yeah.
CBDRC for the purposes of this discussion. So the court distinguished between developed states, which it described as having, and I quote, contributed significantly to the overall amount of greenhouse gas emissions since the Industrial Revolution, and which have the resources and technical capacity to implement wide ranging emission reductions, and developing states, which it noted, and I quote, contributed only minimally to historical emissions and have only a limited capacity to transform their economies. So, in this context, the court affirmed that international law must reflect the disparity and that the principle of CBDRC requires developed countries to shoulder a greater responsibility for the burden. So, they're in that sense expected to meet a higher standard of conduct in discharging their obligations to prevent environmental harm. That being said, the court was also a bit careful in defining sort of this divide between the developed and the developing. And in that sense, it is said that this principle is not limited to a rigid developed developing binary. Rather, it must also take into account each state's national circumstances. And as a state develops economically and gains greater technical and institutional capacity, its level of responsibility and corresponding obligations could also increase. Now, what does this mean in practical terms? The court provided some important clarifications. For example, in the context of UNFCCC and the Paris Agreement, it would be no surprise to you and many of the other international lawyers that both of these regimes focus on common but differentiated responsibilities already in the text. So the court's job was sort of merely to look at the text, interpret it in a way that sort of gives effect to the intentions of the drafters of these treaties. So under the UNFCCC, for example, all parties are to develop, report on national policies, programs, and measures to address climate change. However, developed country parties, particularly those listed in Annex 1, have additional obligations, the court said, namely to adopt policies and take corresponding measures to limit GHG emissions and to protect and enhance carbon sinks and reservoirs. Under the Paris Agreement, the court stressed that the formulation of NDCs, the nationally determined contributions, must take into account the CBDRC principle. This means that while all states must contribute to the global mitigation effort, the expectations placed upon them are not uniform, and they must reflect differences in capacity, responsibility, and national context. And then, in regards to the duty of prevention, and in fact, before I get to that, one more point which I think will become important as we discuss the repercussions of this advisory opinion is that the court also said that under the broader climate regime, developed states bear the primary responsibility for technology transfer and financial assistance to developing countries. Now, quickly on the duty of prevention and how that ties into CBDRC, the court held that the obligation of a state to use all means at its disposal to prevent harm to the climate system implies that the level of due diligence required will vary depending on a state's capability. So, developed states, for example, who have greater access to scientific, technical, and financial resources, are held to a higher standard of conduct. And this duty also requires states to actively seek out and apply scientific information necessary. However, in the context of many developing states, where a state lacks the capacity to access or act on such scientific information, a failure to take appropriate measures may not automatically constitute a breach of the due diligence standard. And in that sense, the court gave effect to many of the obligations, but remained mindful at all times about the principle of CBDRC. And if you go through the judgment, especially the dispositive at the end, the court is very mindful of placing in the right places this principle and how it affects the interpretation of all of the applicable principles.
Okay. So I think the one thing that is being talked about right now about this advisory opinion is pertaining to the non-binding nature of these opinions. Like, how useful are these, like, realistically and practically? So, since advisory opinions are non-binding, right? How can the ICJ opinion be used to advance climate justice and accountability in the global framework?
Right. And I think it's a fair question to ask, especially those of us in international law know that it doesn't necessarily work in the way, let's say, a global or let's say a domestic court does. But that's not to say this opinion is just sort of a very long statement of what international law says about climate change, but I think its impacts are far reaching. And the court's advisory opinion is historic in many respects. So, to begin with, this was the most widely participated proceedings in the ICJ's history. And Pakistan joined over 100 states and international organizations in presenting its views. And importantly, the opinion was adopted unanimously. And interestingly, this is only the fifth time in the nearly 80 years of the court's existence that it has issued a unanimous advisory opinion. And that alone underscores the buy-in of states and international organizations, but the seriousness with which the court dealt with the gravity of the questions raised. Um, Now, you've rightly mentioned, as it is in its name, the advisory opinions are not binding. But they do still carry considerable legal authority and they can be impactful in a number of ways. Some of them you've alluded to already. So, for example, accountability and climate justice more generally. So, I think one of the most immediate uses of this opinion will be climate related litigation,
Yes.
because the court has now articulated standards around due diligence, the duty to regulate private actors, for example, and the recognition of human rights and their relevance to the discussion on climate change. We can expect litigation arising from, of course, breaches of human rights that result
Mm.
from climate change. We've already been seeing that in different jurisdictions as well as before the Human Rights Committee, the treaty body of the ICCPR, but we'll start to see much more of that,
Mm.
where states have adopted weak nationally determined contributions. There is an argument to be made that they could also be sort of, let's say, litigated in domestic courts. There will be more pressure for approvals of projects, or rather fossil fuel projects
Yeah.
that are granted without significant environmental impact assessments. And there will be more pressure on states to regulate private emitters or enforce climate obligations as regards to those private actors. So given these trends, I do see that there would be an increase. When that increase occurs is up for debate. We can speculate, of course, but I do anticipate an increase in claims seeking injunctions, reparations, or
Yeah.
enhanced regulatory action from states. But
Yeah.
that's not the only thing that's going to happen. Uh, this will impact interstate relations as well. So I hope we'll get a chance to discuss Pakistan specifically, and then these questions will become clear. But in the more abstract term, uh, during the proceedings, for example, some states argued for a narrow interpretation of obligations in the UNFCCC and the Paris Agreement, as I mentioned, and framing these issues as well. Financial assistance is fine, but financial assistance is not tied to any sense of legal obligation or legal conduct that breached international law. Instead, the
Mm.
Warsaw Mechanism, the Loss and Damage Fund, it arises because states or developed states want to provide financial assistance for no reason tied to any legal responsibility for
Yeah.
greenhouse gas emissions. That argument is, of course,
Mm.
no longer valid. So injured states will get a robust legal foundation to invoke state responsibility for the harm they've suffered. They will have a legal basis to demand cessation of wrongful conduct and
Mm.
ask for assurances of non-repetition. um, they can support claims for reparations, whether it's for themselves or for the injury to other
Yeah.
actors. And then, of course, it will strengthen the position of states impacted by climate change. Now, the 1.5 degrees Celsius target. So, what does that mean in practice? It will, in my opinion, strengthen the bargaining power of vulnerable states in future negotiations,
Mm.
particularly in upcoming COPs, the loss and damage financing frameworks, as well as for calls which are calling for a more ambitious fossil phase out plans and the technology transfers that are associated with that. And on multilateral forums and treaty bodies, we can expect, I think the first thing we can expect, in fact, this is the fastest thing which will probably occur, is that this will go back to the UN General Assembly because they
Yeah.
requested for the advisory opinion. And there, I expect the UN General Assembly to welcome this advisory opinion with overwhelming support. Now,
Mm.
why is that relevant? One, it shows the buy in of states. But two, anything that the UN General Assembly says is incorporated into UN's broader policy,
Yeah.
particularly, let's say in regards to UN agencies and development frameworks that they have. Then human rights treaty bodies. We've already alluded to that as well, such as those monitoring the ICCPR, CEDAW, the Convention on the Rights of the Child, will increasingly get a basis to integrate the climate dimension into their interpretation of existing rights, especially with the court now noting the recognition of a right to clean, healthy, and sustainable environment as a precondition.
Yeah.
Then the decisions by the COP or the CMA under the climate framework are likely to take into account the court's interpretation for any future decisions made by them. And finally, or in fact, two more rather. Let's give
Okay.
the audience two more. So regulation of private actors and corporate accountability. So this is very much down the line, and we can't expect this to happen immediately, but at least starting, I would say, somewhere within Europe, there will be calls for stronger corporate disclosure regimes on
Mm,
climate risk and emissions, which are already there. But I sense that this will build on existing efforts and calls that are made in that regard. More pressure for climate aligned corporate transition plans and the development of liability framework for businesses, and then finally, cross fertilization of climate change obligations across jurisdictions, because we've seen, of
mm,
course, the Inter American Court of Human Rights recently giving a very robust advisory opinion
yeah.
in relation to the Americas and the Inter American Framework on Human Rights. Then, of course, we've had uh, it lost the International Tribunal for the Law of the Sea that clarified states' obligations under the UN Convention on the Law of the Sea. So in that sense, I think change is never immediate with advisory opinions, but it provides impetus for the many movements that are already in place to sort of mount, let's say, different strategies to curb the
Mm,
emissions and
mm,
hopefully cap the increase to 1.5 degrees Celsius. And I think that's how the opinion will manifest. It may not be in the most tangible of ways in the short term, but I think down the line it will definitely have a much greater impact.
yeah, hopefully. Okay, so as you mentioned, now let's come a little closer to home. So, how does the ICJ advisory opinion enhance Pakistan's legal and diplomatic standing in the global climate justice discourse?
I think this is a very interesting question, and there are several dimensions to it, which I think are relevant as regards to what I've already mentioned. So, without repeating myself, so Pakistan, as we know, has long positioned itself as a vocal advocate for climate justice in
Yeah,
international forums. Um, we are a low emitter, but we're also, unfortunately, a climate frontline state, and we've consistently highlighted at international forums the disproportionate burdens that we bear for the
yeah,
actions of major emitters. The advisory opinion now, I think, significantly affirms and elevates that stance by providing not just sort of a moral impetus, but also a legal impetus for Pakistan's diplomatic efforts. I think the court's recognition that failures to meet climate obligations can trigger international responsibility,
mm,
including in particular the obligation of reparation and compensation,
okay,
will allow Pakistan or should allow Pakistan to move beyond merely just moral appeals. I think Pakistan now has a tangible legal basis to
mm,
demand climate reparations from historical emitters, not merely as a political claim, but as a matter of legal entitlement.
yeah,
And I think this will also play out in multilateral forums such as the UNFCCC, the COP framework, the UN General Assembly, and a number of other forums where now we can actually make these calls based on a legal argument. The opinion will also reinforce Pakistan's position on the responsibility, or rather, the differentiated responsibility between the developed and developing states, which Pakistan can invoke to push back against disproportionate mitigation expectations,
mm,
and particularly developed states expecting developing states like Pakistan to, have
yeah,
an across the board NDC and to comply with all of these targets that have been set. So I think the court's assessment as regards to CBDRC will make things more realistic in respect to what can be expected from countries like Pakistan when it comes to mitigation and adaptation. And in addition to that, as regards international cooperation, now I mentioned earlier that this is now a legal obligation.
yeah,
So Pakistan now has a footing. Well, in theory, it already did under the Paris Agreement and UNFCCC as well as other
yes,
conventions. But now it has an even greater legal footing. So it could demand technology transfer, climate finance, as well as to develop mechanisms for early warnings. And this is no longer optional. This is a binding legal obligation. And uh, I'll I'll conclude with a few last points,
okay,
which is that Pakistan's robust participation, I think, in the ICJ proceedings was a welcomed initiative, and that's largely because the alignment of the court's advisory opinion was seen with many of the positions that Pakistan put forward. And because of that, I think Pakistan has enhanced its normative standing in international climate diplomacy. And I think this is a great time where Pakistan can build on this momentum to more forcefully advance its positions on climate justice, backed not just by political urgency, but by authoritative legal reasoning.
Great. So, Shayan, I think this brings us to the end of our podcast. And thank you so much for such an insightful discussion. And we will for sure keep asking you for your expertise on the matter again in the future, as well as the developments take place. A very interesting discussion, and I'm sure that our viewers would also be enlightened. Again, thank you so much for coming on such a short notice. We're really grateful. And I would also like to thank the viewers for watching. Please subscribe to our channel to access more of our content. Thank you.